Hey everyone, Jason here. I just want to do a really quick video, um, kind of like make a shout out to Braden of Langley Outdoors Academy. Sunday evening, he did a nice little story on a news report of potentially what the ATF's strategy for justifying their regulation or ban on forced reset triggers. As many of you know, I'm a connoisseur of rapid trigger manipulation, whether it be bump fire or the forced reset trigger that I'm not allowed to have anymore. Um, but basically, that report talked about how um, the ATF is just approaching this as basically along the lines of how fast it shoots. And it obviously, machine guns are not defined by the speed in which they're able to empty a magazine. If that were the case, guys like Jerry Miculek, he'd be registered as a machine gun, I guess, or pretty much any semi-automatic could be considered to be a machine gun because you can shoot it that fast. And that's not the way the statute's written. So one thing I wanted to touch on based off of a lot of this reporting is the fact that we've already had a case that was pretty much the decision, included in the decision was a clarification of what a machine gun is and is not. And that particular case happened to be the Cargill v. Garland case, involving bump stocks, where the Fifth Circuit, and I'm going to read you what they wrote, basically clarifying the statutory definition of a machine gun. The Fifth Circuit wrote, the statutory definition of machine gun utilizes a grammatical construction that ties the definition to the movement of the trigger itself and not the movement of the trigger finger. Nor do we rely on grammar alone. Context firmly corroborates what grammar initially suggests by demonstrating that Congress knew how to write a definition keyed to the movement of the trigger finger if they wanted to, but they did not. The government offers nothing to overcome this plain reading, so that we are obligated to conclude that the statutory definition of a machine gun unambiguously turns on the movement of the trigger and not the trigger finger. So ATF's claim, if you read this thing they send FFLs, and I guess they're handing these out. I downloaded this off of some website. If you read that letter, the way they describe function, the single function of the trigger, to mean basically single continuous pull of the trigger. The statute does not care what your finger does. Anyway, that's what I got. That's what I wanted to put out there. We already have, a win on this in this Fifth Circuit, and, thanks to Lawrence DeMonico and National Association for Gun Rights and all the plaintiffs in the Fifth Circuit, to bring this to that court. This could be a very good ruling when it comes to the forced reset triggers. Anyway, I'm rambling. Everybody have a good rest of your week, and I'll see you on the next video.